Ed A. Mutuba, who's the Dean School of Law, Mount Kenya University. And his paper is on African regional communities ready for climate-related litigation, normative and institutional design considerations. I would like to pretend that I know what the French version of what Mawuto Tosa would present, but I wouldn't like to embarrass myself. So I'll ask him to please kindly tell us the title of his presentation.
The title of my presentation in English is Dispute Settlement in the Annex to the Protocol of EFCFTA on Investment, a critical analysis and prospective analysis. This is the title in English.
So he's been kind to tell us he will proceed with English for the panel so that everyone can listen and understand what he's saying. So for both panelists, they'll be given 10 minutes each for their presentations. I'm very strict with timing. And even if you ignore me, I'm going to tap on this mic. I'm that ghetto. So please we'll try and give and stick to the 10 minutes. I'll start with the Dean.
Thank you very much. I have a PowerPoint presentation. Allow me to say thank you very much for the invitation. I don't know. We are used to speaking 3 hours straight. I don't know how we'll do it in 10 minutes. We'll do our best. The views I take in this presentation, and I will share the presentation with the organizers. I have a PowerPoint presentation and a paper. You will read it for yourself. I will summarize what I can, and when the 10 minutes are finished, I will go and sit down. The views I take are mine, personal. They have no association with any of the institutions I'm affiliated with on the continent or beyond. So I do not want to see, I know students like saying, he said. These are my views, not of any of those institutions unless I want to risk my membership there. But we were encouraged yesterday to speak freely, to intellectually interrogate concepts, to look at context and content, and really where content meets context is in the courtroom. Theory meets practice there. The very good ideas that the scholars here have ably articulated are matters which can only be tested in courts, in litigation, in disputation. And invariably, inevitably, there will be disputes about many of the things we have been discussing yesterday, today, and we will discuss tomorrow. So dispute resolution within the context of the Continental Free Trade Area and the subsets, which are the sub-regional organizations, are inevitable. And I just want to lay a background. And when listening to the keynote speaker yesterday and reflecting upon this topic, something struck my mind that we are talking about climate change, we are talking about initiatives that would mitigate climate effects on the continent and beyond. And it reminded me of some promise that was made by the then candidate in the Kenyan election for president. And he said every household will transition from using firewood and charcoal, and we will all use gas at about $2 or 300 shillings thereabout. You know, when you look at this continent, for those of you who have traveled here, and many of you come from here, you know, we have been accused of elitism and intellectual dishonesty, particularly the people who have gone to school in Africa. If you meet a schooled or educated or intellectual African, he is likely to prescribe a very elitist solution to something that is very basic. So he misses the context, as we say it. The context is really not there. You sit in air-conditioned rooms speaking about problems to people who have not seen air conditioning and dealing with questions. You can see the people speaking about very high-sounding principles about how we can end dollar domination. You know, the truth of the matter is this, that there are 46% of Africans who have never seen electricity. The truth of the matter is also that we have countries today in Africa which are now discovering oil. And you're being told that is fossil energy, don't use it. And you're being told this by people who have used this dirty form of energy for 600 years to industrialize. They have used slavery to advance their cause. And you're being told, leapfrog 600 years and jump into the new era. These are the problems African dispute resolution forums are going to deal with. Are we prepared for litigation in this area? Now, I want to just borrow from the earlier presentations. You see, the first generation of integration in Africa, post-colonial, excitement in the air, we are free, self-governing. So it's really a forum for emancipation, people discussing the war stories. You know, if you have met war veterans, they tell you about their stories. So that is really what the OAU was about. After that came the era of liberalization. So the idea was to liberalize trade is what will get us to economic emancipation. So we tried this in the 80s, in the 90s, early 2000s. We have now a third generation of thinking around integration. And the third generation is now about the third or second generation rights, depending on how you look at it as a human rights scholar. So much that you're now talking about freedoms, you're talking about participation, you're talking about gender rights, you're talking about climate, energy, and other forms of ideas that are now current. What is the point? The point is this. Many institutions, dispute resolution, in integration efforts in the continent in the 60s and in the 70s remained moribund. Most of them recorded zero caseload because the framework under which they were operating did not really prepare for disputes, because this was really an intergovernmental kind of arrangement where states would discuss trade and enter into agreements, treaties, and eventually the understanding was that the dispute resolution fora that was created was meant to resolve state-to-state disputes. As the economy is liberalized, then you move towards investor-state disputes. And today, I must say that we have grown now. We are in an era where beyond state and state disputes, investor-state disputes, you now have disputes in the public interest. So that is another area that is emerging. And therefore, the current dispute resolution system that you will see on the continent in economic communities mirrors at least three efforts: disputes at the state level, investor state level, and then we have disputes in the area of private disputes, including public interest disputes. So when you look at the context of dispute resolution within the economic communities in Africa, one of the things you now see is that the dispute resolution fora that is available is to test or interpret treaties against actions of public bodies, private bodies including investors, and to also entertain disputes or matters that involve civil society, non-governmental organizations, and such. So when you look at climate change as a new era dispute resolution item or concern, you notice something, and as a teacher I must say this. You see, the schools which started offering oil and gas courses now are quickly converting to energy, because it is no longer sexy to say that I'm offering you oil and gas. You must find something that is politically correct. You've been told about professors' view that it must contextualize. You must look at the politics of the day. Oil and gas, oil is now considered one of the bad things to speak about, to look at. But when you speak about energy, multinationals from Europe are now rebranding their fuel stations to call them energy. You've seen that. So no one wants to say this is a gas station or a petrol station. They are now saying this is an energy company. So what is the discussion today? Now, my research around the area was to answer at least 3 questions. Are our dispute resolution forums, whether they are courts, tribunals, whether you call them arbitral tribunals or court forums, courts in regional and sub-regional bodies, including the Africa Continental Free Trade Area. Wow. Whether they have the jurisprudential remit to deal with these questions. You know, when you look at the history of dispute resolution, particularly in economic integration in Africa, the first thing you realize is that the jurisdiction was constricted. You had either to be a state to present a case, or you came through diplomatic protection through your state. And therefore the question is, have we expanded the jurisdiction enough to entertain disputes beyond the traditional state-to-state disputes? Do we have the technical capacity? Competence is important because the men and women who sit in those courts, unfortunately, are appointees of the state. Usually, these are politicians who have not succeeded in the previous election, persons who are being rewarded with a political office to earn an income without any understanding. You know, you go and find a gentleman you have put there who was previously maybe a primary school teacher or somebody coming, or somebody who is a judge or a lawyer who is politically being rewarded to sit in these places, and he has to decide very technical questions. Faith and the team will go before them with a dispute regarding the payment system under the Africa Continental Free Trade Area. The gentleman or lady or the judge has never heard about it. And you are now putting the fate of 1 billion Africans in the hands of those people. That is the reality of the day. Thirdly, do we have available tools? The declarations, the damages, the reparations, the tools, the powers, the effectiveness of the remedies that are available. You will notice that it is a whole debate whether or not you can approach some of these dispute resolution fora as ports of fast ports of call, and what remedy they can issue beyond declarations. I know there are some very eminent gentlemen in this room who have filed some suits in the public interest in some of our courts. They will have to contend at some point with what comes out of that decision into the realm of reality.
Try to.
I am now trying to wind up. If you give me 5 minutes.
No, you don't have 5 minutes. I've given you an extra 2, so just try.
Thank you very much. So the questions that are going to, and I may not even go into the slides, there are 14 slides I will not manage. The challenges we are seeing in the framework that we have in the Africa Continental Free Trade Area, including the dispute resolution or dispute settlement system, is the approach that still, and Faith had referred to this earlier, that still requires or still encourages that there are multiple fora for dispute resolution across the continent. What happens is that you have a situation where the continental framework is not hierarchical in nature, so that you do not have the Africa Continental Free Trade Area dispute settlement system as sitting on top of a system that is cascaded. You still have courts across Africa in sub-regions exercising exclusive jurisdiction on matters which affect their regions, and you have the East Africa Court of Justice, the COMESA Court of Justice, the ECOWAS Court, all of them promoting and pushing an agenda in this space. And therefore, these are available fora for dispute resolution, including the Africa Continental Free Trade Area dispute settlement system, which is not an overarching system that is hierarchically above the other system. So it is just one of those that are available. And therefore, when you look at the architecture of dispute resolution in Africa, particularly where we are going to deal with climate change disputes, you do not know exactly where to start. East Africa has a policy, the West Africa has a policy, Africa has a policy. The idea is that these policies must feed into a continental approach. But the dispute resolution system does not necessarily feed into a continental approach, except for what is aspired under the Africa Economic Community Treaty and the Abuja Treaty. I have challenges with time.
Yes.
The paper is available. I will take questions. The truth of the matter is that the challenges we have identified in
Dean,
the paper.
sir, you've exceeded my
All right.
timing. Thank you.
Thank you very much.
You'll have opportunities to say more during Q&A. Thank you so much. You must
thank you
stick
very
to
much.
time.
All right.
Good afternoon, ladies and gentlemen. My name is Mauto Tosa, and I've recently defended a joint PhD from the University of Lomé, Togo, and University of Granada, Spain. Allow me to express my pleasure to be here at this scientific event and in Tanzania, which is the first time, and to extend my gratitude to the conveners of this event. I prepared my paper in French, but I didn't want to be the exception to the rule, and I decided to share my thoughts in English. So I want to share my thought about the dispute settlement in the annex to the EFCFTA investment protocol. But we are sure and we know that this protocol is not yet adopted. And my view will be its prospective analysis of what could be done in the context of this instrument. So the instrument, I mean the protocol of investment of EFCFTA, has been adopted in February 2023. And there is a rendezvous clause in Article 43 that says, I quote, rule and procedure governing dispute prevention, management, and resolution of dispute covered by this protocol shall be set out in an annex to this protocol. The annex should be negotiated after the adoption of this protocol by the Assembly of Heads of State and finalized within 12 months at the latest from the date of adoption of this protocol. I'm not good at mathematics, but I know that we have exceeded the period scheduled to adopt this annex to the protocol. So my vision is that being here, it is a conducive place and time to raise awareness. But this is not the focus of my intervention. My intervention will be this question. What will be the possible and even the plausible avenue for investment dispute settlement in the pending legal instrument, I mean the annex? This is the central point. And the first pillar of my reflection is a possible integration of ISDS mechanism in the annex to come. And why? What are the reasons why I think the ISDS mechanism could be introduced or integrated to the annex? The first reason is that African states have an ambiguous relationship of love-hatred relationship with arbitration. They say they don't want it, but most of African states keep adopting this mechanism in their national laws and even at regional level. And another consideration is that this consideration stems essentially from the Pan-African Investment Code, which says member states may, in their line with their domestic policies, agree to utilize the investor state dispute settlement mechanism. And I think this instrument, the Pan-African Investment Code, has an influence on the decision made by negotiators of investment provision. There are some other reasons for this contention. The ISDS mechanism could provide and ensure legal security on investment in the African countries. And when we see the weakness of our most national jurisdiction, negotiators could be prompted to consider international arbitration in the investment annex to come. And another reason is the political instability in our countries, which induct poor jurisdiction in our country. And when we take the example of Western African countries, Burkina Faso, Mali, and Guinea, where there are coup d'etat, all those things can prompt a negotiator to think about international arbitration rather than going directly to national courts. So possible provision to that consideration. When we take also the regional economic communities investment document, they don't reject absolutely ISDS mechanism. They they have decided to reform it. When I take the ECOWAS investment code and COMESA area, Common Investment Area Agreement, they reform the mechanism and they establish stringent requirement to restrict resulting to international arbitration. If negotiators of the protocol decide to introduce ISDS mechanism, it is certain that they will require investors to exhaust local remedies. And a South African lawyer says something, and I share his opinion. He says that the exhaustion of local remedies rule, if adopted in the framework of the AfCFTA investment protocol, could help both strengthen and integrate the domestic and international system. It can also help to foster well-functioning judicial institution in host state, and I share his view. And last point, the second pillar of my reflection is a desirable uh, inclusion of counterclaim mechanism in case of arbitration in the annex to the investment protocol. And because counterclaim are a certain counter attack to the offensive carried out by an investor against a host state. And this is the metaphor of a soccer lover. And counterclaims are usually admitted, but this admission uh, also express a reaffirmation of state in investment arbitration. With counterclaim, we have a balance of power between the party to a dispute. What could be the approach? The approach to the counterclaim mechanism could be the one devised by in the Pan-African Investment Code, which say member state may initiate counterclaim against investors before any competent body dealing with a dispute under this code for damage and other relief resulting from an alleged breach of the code. If arbitration is envisioned, the counterclaim mechanism will undoubtedly, I think so, in this way, taking inspiration from the new African Regional Investment Agreement also. In this respect, counterclaim could provide a significant advantage to EFCFTA member states in that they would render enforceable the obligation, human right, labor right obligation contained in the investment protocol. To sum up, I will say that the EFCFTA investment protocol is an ambitious legal instrument, and this hard law continental investment instrument should succeed where the Pan African Investment Code has failed. But the annex to the investment protocol that is supposed to contain dispute settlement mechanism has yet to see the light of day. Should it be adopted, it is safe to say that investor state dispute settlement ISDS will be introduced despite the criticism leveled at it over the past decade. Provision on counterclaim mechanism would be therefore desirable in order to set balance between investor and host states on the African continent. Thank you so much for your kind attention.
They've both set the context in two different aspects. One, on climate-related litigation, and on the other, we have investment dispute settlement issues, right? So for Dean Wilfred Matubwa, I had read your paper, and there were certain things I thought would be highlighted. So I will just summarize. His main thing, the question was, are African regional communities ready for climate-related litigation? And his primary argument was that climate litigation at the regional level has the potential. In your paper, you highlighted that only 10 climate cases, even though Africa is one of the most vulnerable regions in the world. And then he also highlighted that the idea or even the concept of climate litigation is defined by global North scholars. This definition, does it have anything, or is there any correlation between this definition and why it might seem that we do not even have sufficient, because I think you query the fact that there should be more climate related litigation. Is it possible to say that because the definition or what we expect climate litigation to be is as defined by global North scholars? And then finally, you kind of emphasized the need to always discuss within social, social context should be prioritized in discussing the issues. And so the question is, are there alternatives out strict legal or black and white legal or black and white law frameworks that can help actualize litigation and tackle issues around climate change that affect Africa? So outside of the text, what would you recommend? Thank you for keeping to time. And what I could take from you is that the addition of a dispute settlement mechanism in the investment protocol, first of all, it hasn't seen the light of day. And you believe it's an ambitious legal document. And if I'm right, you're suggesting that in the absence of what the dispute settlement mechanism in that annex, in the failure of that thing to come to materialize, we will need to depend on the ICSID procedures, okay? But you feel like there's a love-hate relationship. So outside of arbitration, what else do you think, if you look at Africans and the way they resolve their disputes, do we only resolve disputes in, in the form of arbitration? Are there other ways that you can say, African ways of resolving disputes, that we may begin to think about as we are trying to rethink any of the protocols? Okay, so are there African ways? Are there ways within Africa in our traditional systems that we see have been impactful in the way we resolve disputes amongst ourselves as individuals or trading groups that could be imported into these frameworks that might be helpful to resolve some of the issues that you have raised? So I'll give them some time to respond and then get questions from the audience.
Thank you very much, moderator. The truth of the matter is that the advancement in integration efforts on the continent have partly been spurred by public interest litigation. You see, publicly spirited people who move these tribunals have pushed the boundaries, pushed the limits of treaty interpretation. Remember, these tribunals, these courts, have some circumscribed jurisdiction until they are pushed by litigants to see things beyond what the black letter law says. And you look at the East Africa community, for instance, you will notice that many of the advancement into the areas of human rights, into electoral justice, into matters, even arbitration, are really matters that have come out of decisions interpreting the mandate of the tribunal, because the tribunal interprets the treaty and the application of treaty to situations, and you can see that there is an advancement in the manner in which the court has seen its mandate or remit beyond the traditional trade disputes that fall within its mandate. And therefore, What would be encouraged is to have more litigation, particularly in some of these emerging areas, so that we can test the limit, we can test the extent and elasticity of those treaties and protocols in the area. The second question you asked, are there other approaches? When you look at the dispute resolution protocol or settlement protocol of the Africa Continental Free Trade Area, there is some African flavor, what I could see as African approaches. Africans are big in mediation, conciliation, the use of elders, wise people, conciliators, good officers. So those have been incorporated. You will see arbitration. I see the cocktail of dispute resolution approaches, mixed grill or cocktail sort of. So you have the traditional, the traditional approximation, the approach which Africans like to cut and paste from other places. You have the WTO approach, cut and paste, put there. Some arbitration in there, mediation, everything has been thrown in and you're being told, choose what works for you. But the challenge is this: when you have very many dispute resolution approaches in one document, when a dispute arises, the first dispute is the choice of forum or choice of dispute resolution mechanism. Because all these approaches then are available to the parties, and clever parties who want to avoid the dispute may make even the choice of forum itself a question in itself. So again, you see that approach. Then lastly, you asked what can be done to improve the approaches. The truth of the matter is this, that approaching international courts, even for most domestic lawyers, and those are the people who have contact with businessmen, with states immediately, is a daunting task because many of them do not have the exposure or experience. Yesterday you heard the law school speaking about training. Most people are trained to litigate in the domestic court on basic matters in a straightforward manner. When you bring disputes involving international, transnational, or cross-border commerce, it becomes a challenge even to choose where to go to. So the beginning point is to have the capacity, the competence, the information with the people who make decisions in the state and within the organizations which have to use these mechanisms. Let me allow my colleague to also weigh in. Thank you.
Thank you so much for your question. I remember a quote from Cecilia Malmström, who is former trade commissioner of the European Union, who says that ISDS is the most toxic acronym in Europe. ISDS implies recourse to arbitration, but I think this could be less toxic in the African context when African states meet somewhere for arbitration. It's less toxic. But the protocol investment of the AfCFTA is cautious. The drafters are cautious enough to envision some mechanism to resolve investment disputes settlement. There's a amicable dispute settlement mechanism that negotiation, consultations, conciliation, and mediation. And I would prefer mediation. Mediation that we call in African context l'aba palabre in French, that people meet to resolve their problem in a more peaceful way than going in front of a court to have their problem solved by a judge and other persons. So mediation would be my preference among all those mechanisms before resorting to arbitration. And in my presentation, I said that there are many restrictions to arbitration that the drafter could introduce in the annex to not go directly to arbitration when there is a problem between an investor and a state party, because we are among African. That's what I can say.
Do we have any questions? Oh, okay. I'll start with Professor Obiora Okafor. We'll hear from those who have not spoken. Bakita. So in that order for now.
Thank you so much to the panel. I quite enjoyed your presentations, and if the chair permits, I have just one quick question for each of them. To Dean Wilfred, I get your point about fragmentation and lack of hierarchy, right? But is this mediated, or if you like, is that problem attenuated by the fact that most of the jurisdictions are sort of the disputes to be instrument or context determined, right? So depends on, as a lawyer, I used to practice law, so it depends on what the issue is and how it arose and all that. So you understand. So that may attenuate it a bit. I don't know what your, just to hear your thoughts. And quickly to Mauto. Um, yeah, I would like just to hear more. I'm very interested in your point that exhaustion of local remedies would strengthen our local judiciaries. I mean, I would love for exhaustion of to be introduced. When it comes to the ECOWAS court, I'm against introduction of exhaustion of remedies in the human rights context, which is my primary field, right? But in this case, for reasons I can't get into, I don't have time, I would support it here. But in terms of strengthening our domestic judiciaries, I would like to hear more about the details of that, the logical flow of your thought. Okay, thank you.
So Bakita, she's here.
Yeah, thank you very much. I think my question ties in with Prof's question. I'm also looking at the issue of exhaustion of local remedies. And my question is, how effective do you think that would be in terms of the challenges that are existent in local forum? If you take Ghana, where I come from, we have a plethora of cases like the Balkan Energy, Isoferton, Waterville, Faro Atlantic, where you would see that the inclination of the local courts is to protect the interest of the government against these people. So would it even make economic sense for the investor to pursue local remedy, first of all, before looking at other dispute resolution mechanisms? So this is my question to you. How can we ensure that the challenges inherent in the local remedy approach are resolved towards giving, better opportunities for dispute resolution?
Okay. It will be Luam and then Kanyiri.
Thank you so much. My question is flowing, I guess, from the previous two questions. So this question of exhaustion of local remedies, would the ISDS consider the AfCFTA or any of the sub-regional integration dispute settlement mechanisms decision as exhaustion of local remedies? What is going to be that relationship? Right? Are you speaking about it at the state level or at the sub-regional and continental level as well? That also ties with Dean's presentation about multiplicity of dispute settlement mechanisms within Africa.
My question is to either of you. Climate litigation and arbitration exists to clarify the issues or the weaknesses in the climate change regime. One, so far we have seen that the clarification has been sought by, first was the COSIS, the Coalition of Small Island States, and the other one was the General Assembly, to clarify what the responsibility of states is vis-a-vis and the legal consequences. What other weaknesses in the climate change regime do you think are to be addressed through climate change litigation?
I think that question is more directly to you. Okay, so let them try to answer this round of questions. Oh, please, Harrison, by all means. And then they'll try to answer the questions and we'll see if we have time for more.
Yeah,
Okay,
thank you so much, Susie, and thank you, Regis, for vouching for me. Mauto, mine is very straightforward. I mean, if Europe is saying ISDS is bad for them, how can it be good for us? I mean, they're saying it's bad for them. How can this be good for us? Maybe you can tell us because I don't see it.
Okay, so we'll try and Mauto, you had a lot of questions, so try and
I will start by the question of Dr. Mbori Harrison. Um, I'm not saying that ISDS will be good for us. I'm saying that drafter of the annex would maybe they will uh, introduce this provision in the annex to the protocol. That's what I really mean. But between African states, if ISDS is bad, I think it's most of the time between foreign investors and African state, non-African investors and African state. But I have faith that between African investors, intra-African investors, and African state, maybe it will function. Why? When it is said that the dispute should be sent in front of local or African arbitration institution, I hope this could work out when it is among African. And knowing our realities, I think the trial or the decision made by the uh, arbitral courts will not be decision with high amount of money because we know our condition on the African continent. It won't be the same as in front of Exit or other international London Court of Arbitration or something like that. So it is my hope that this will help African states because we are among ourselves. So the question, there is a huge issue about the exhaustion of local remedy. And this is reasonable because exhaustion of local remedy problem shows a lack of confidence in our national jurisdictions, national courts, a bias or impartiality of our judges and maybe lawyers in other aspects. But it is necessary to enforce or to give the opportunity and training to lawyers and sensitize maybe those of the judiciary to be more impartial in how they take decision. That's why it is necessary to talk about the AfCFTA, have program on campaign around the AfCFTA in each member state to say clearly that we have a new mechanism, we have a regional instrument, and you have to be impartial in how you take your decisions. So I think this is what should be done if I have not left behind another question. Yes, we should have, yes, I believe that our court can do a good work if they have this conscience that we have to help our new continental organization go forward and to promote trade and investment on the whole continent. I think that's what I could say about this issue. Thank you.
Let me say something. I will answer the question on exhaustion of local remedies together, all the questions put together, by giving one example. Today in Tanzania, there is a statute that has basically says that all disputes regarding investment or touching on natural resources must be determined in Tanzanian courts. The idea was to avoid international investment arbitration. And number two, the new Tanzanian Arbitration Act also requires that for you to practice arbitration in Tanzania, you must be a Tanzanian, number one. Number two, you then have to be registered in Tanzania. Now, the point is this. The reality about courts, now we are talking reality as opposed to theory. The reality is that courts, whether regional, international, domestic, usually are averse to the possibility of external or other tribunals taking their jurisdiction. So they try as much as possible to accumulate jurisdiction. When you go to a court and you say this court has no jurisdiction, the first reaction you see from the judges is, how come? And they will try to navigate and find jurisdiction. So when you look at exhaustion, you must look at it as opposed to exclusion of jurisdiction. Some people don't like exhaustion as a term because it suggests that you still can go elsewhere. And some people believe in exclusive jurisdiction, particularly in the domestic courts and even in regional courts. The issue is this, and I now take Prof's question. if we are building a truly continental dispute resolution or even a truly continental integration effort, economic integration under the Africa Continental Free Trade Area or the Africa Economic Community, then there must be a way in which when we say that the sub-regional bodies and the sub-regional organs, including the East Africa Community, Court of Justice, ECOWAS Court of Justice, all these courts that have been identified, all these organizations must feed into a superstructure that reaches a point of regional integration. How do you do that when there is no nexus between the court in East Africa and the Continental Tribunal? How do you have integration feeding into one another and getting into a continental dispute resolution mechanism without highlighting whether, in fact, decisions of the East Africa Court of Justice can be appealed or reviewed or revisited by a continental forum, so that you have disparate approaches without the ability of the level which you want to say is the supreme African continental approach having jurisdiction to deal with matters which are coming from these organs. So the exhaustion that I would advocate for is one that the local remedies are subcontinental, then you have a continental hierarchy going into that court. It may or may not work, but if you really want to have a true integration economically at the continental level, you either have to eliminate these bodies down here, or you must find a way of drawing a relationship between them and the body that you're creating at the continental level. You now have an African single court, and you're being told this is the Africa single court. You're going to hear disputes, whether they are, economic trade disputes, and then you're going to deal with human rights disputes, but there is no connection between them and domestic courts and sub-regional courts, everyone operating independent of the other. The second and last question I wanted to answer is Dr. Mbori's question. Investor-state dispute settlement, the numbers don't lie. Sometimes, when I listen very carefully to what people say, year on year, the number of international arbitration, whether it's commercial or investment, are going up. And every year, the number of arbitrations settled or had and determined in London, in France, in Africa is going up. But you are told this is a crisis. This system has a crisis. It's a bad system. It's a broken system. People don't want it, but they keep preferring disputes there. Exactly what is the reality and what is the fiction? The system may have its own problems, and no system is better than the other, including these systems we are talking about will face problems. The question is, what is fundamentally wrong with the system, and how can that be improved? Because I know that today, when you speak to investors, people who come to Africa to invest and we represent them, they still want to go to arbitration. They still want to go they want to go to ICSID. But again, we as Africans then say this system is actually designed to be against us, or to have decisions going against us. But what we need to do again, and I see it as a progressive way of moving forward, is efforts like these ones where we now have a continental arbitration effort for disputes with regarding investment across Africa by Africans, between Africans. It gives us a platform to say that we have an alternative. But I always ask this: ISDS is bad. Regional courts are bad. Domestic courts are bad. So what is it that is good? What is it that we have to do? Thank you.
Okay, we have about 3 minutes, and Faith persistently had her hands up. Of course, I cannot deny my conference chair. So, Faith.
Thank you.
Yeah.
I have a question that maybe has been answered in so many ways, but I'm just going to say this. Last year, I wrote a paper on a shift towards investment mediation from investment arbitration in ISDS, But I did exactly what you said. I pointed out that people are saying ISDS is bad, but the numbers are going up, cases are going up. So I said, instead of wholly removing investment arbitration, I said let's expand the cooling off periods, right, before investment arbitration. Is that a feasible option in climate litigation? And still on that comment, I'd like to speak to Mauto. Yeah, maybe we can look at my paper and then we can collaborate and write a bigger one. All right, thank you.
Thank you. So that will be Regis.
Madam Chair. Well, my question is to Mauto. I was wondering, because you mentioned at some point that African countries might not be using the investment arbitration that much against one another, right? I was just wondering whether, having looked at the case of the Diallo at the ICJ, would you still have the same comments? Do you think that these are the cases that should have been litigated on the continent, or do you think that by having in place another investor in IFDS in place, that will have escaped jurisdiction of the FCFTA if it was in place at that time? And have you thought, both of you, about the OHADA scheme in your research, whether any of these mechanisms can be included or at least be used and expanded on the continent so that we don't have to look for models elsewhere?
Okay, so Tita, you also be the last question.
Thank you very much for the presentation. I have a question for each presenter. And the first one is, since Africa has never developed any instrument on climate change, so what is the point of including it in the instrument in the AfCFTA framework? Because we do not even have a forum where these disputes can be heard. Neither that we have funding to actually implement policies supporting climate change. So why are we engaging with it? And the second question is to Mauto. I'm not very enthusiastic about what you are proposing. And the first reason is that if we consider the exhaustion of local remedies, there's this case, it's Chevron versus Ecuador. And the arbitral tribunal actually said that the exhaustion of local remedies is not absolute. Once there is a denial of justice, the investor can bypass exhaustion of local remedies. So what do you have to say about this? And concerning counterclaims, they have not really been upheld by arbitral tribunals. And it requires a lot of technicity in the drafting of the treaty. In most cases, it's never really upheld. Is there any other solution? And lastly, about mediation, the framework to which we can, yes, I'll shorten, it's really the last one. Mediation would require some form of framework, and it will be maybe the Singapore Convention, but it's not yet in force. And mediation often is confidential, so it will require a framework such as the Mauritius Convention, which has not really been ratified by African countries. So what's the solution, especially when we know the issue of corruption in Africa? There's a risk that claims will be truncated and we will not get justice. Thank you.
Yeah, I will begin by answering to Dr. Regis by saying that yes, we have analyzed OHADA law also. OHADA jurisdiction is a very famous jurisdiction in our region because of the cases it has and because of the solution it has to all the plaintiff and other people as businessmen in general. And it is said OHADA also have a document, a Uniform Act on Mediation and on Arbitration. And once you look at it, all parties to a problem or a case in front of the jurisdiction, most of the time are satisfied with the decision. And I think uh, in the framework of AFCFTA, we can take example or draw inspiration of what is being done in the framework of OHADA. And even if a Caribbean state decided to create an organization like OHADA, and they call it OHADAC, in order to learn more from what is we are doing in the OHADA context and to apply it in their own context because of the success of the OHADA litigation and arbitration system. That can help EFCFTA member state or even drafter of the annex to the protocol to look at what is done in the context of OHADA. And maybe the first question, the in African states say now that let's keep it local. What is arbitration? What is litigation between investors and state? Let's keep it local by resorting to national courts or by going in front of African arbitration institution. So if you take the legal document, a legal investment document of regional organization, you always see this mention of local tribunal and arbitral decision. And so I would say with them, let's keep all local in the context of AFCFTA. Yes, to Tezeta, I'm not proposing. I said dispute settlement in the annex to the protocol. Prospective study. I look to the future. What could the drafter do? I don't know what would be their decision. So I'm not proposing. So about the exhaustion of local remedy, when we come back to this huge issue, the recent document of ECOWIC, you take the COMESA investment document, the most recent. All those documents restrict arbitration. They restrict access to arbitration by envisioning the exhaustion to local remedies. This means they have faith that their local jurisdiction will do a good job to be impartial and independent when it's come to resolve disputes between investors and home state. So it's not a proposal, but I think with your comments and all, we have experts in trade negotiation and dispute settlement experts here. They would have what to tell the drafter of the annex to the protocol to have a very good one. Thank you.
I will be brief because I think some of the answers have come from the audience. You know, to answer your question, Faith, whether we should increase the cooling off period and involve mediation during that period, already in many arbitral clauses, you will find that you have a period within which parties must resolve disputes amicably or attempt amicable settlement. The criticism of domestic courts, the criticism that makes arbitration attractive to some people is because court matters in domestic courts take too long. You know, you take between 6 and 12 years in Kenya to finish a case from one court to the other, 12 years. Now, already there is criticism that investor arbitration, commercial arbitration is taking too long, 5, 6 years. If you're going to create another layer of litigation or another layer of dispute resolution, another 2, 3 years in mediation, what are you doing? Number 3, it's going to be expensive. One other criticism of investment in ISDS is that it's expensive. It's unnecessarily expensive. Now you want to create another layer of dispute resolution, go to mediation, come to arbitration, come from mediation, from arbitration, go to enforcement and setting aside. Those are some of the things people are saying is the problem with the system. So the challenge, when the way I look at it, is a challenge that has to be approached in many ways. You know, when you precipitate a crisis, you must be ready to offer the solutions. The investor-state dispute settlement system has been criticized. Delays, there is a question of counterclaims. Now there is an effort, even in this Africa Continental Free Trade Area arrangement, there is an effort to bring the state rights to bring a counterclaim as a recognized right. Time has been diversity, inclusion of women, younger people in dispute resolution, including questions of costs have been addressed. So the question is really, how do we deal with the problems? Because the system itself can be improved and make it better. Mediation as a place, I have done an investor state mediation. You know that mediation is, first of all, it's voluntary. Again, it is not enforceable. The decision can be thrown away by one party. So people want finality and people want concrete decisions made at the end of the day. That's why I think it is okay in terms of a framework to have all these processes available to the parties. Those who wish to go to mediation will go to mediation knowing the challenges mediation has. Those who want finality will go to arbitration. Those who still want, and where the dispute is amenable to being settled through the WTO style panels, that is another process. So all these are available. And I think for me, I find this approach by the CFTA a very good approach, because it gives an opportunity. Almost everyone has what they would want to do in terms of dispute resolution. Lastly, the mediation framework that is being introduced at the international level and at the regional level. What it aims to do is to create a valve, an exit strategy for those who do not want to go to the formal processes. And yes, it is an encouraged approach. Let's see how it works. It's the mechanics, again, which will determine whether it is successful or not. Thank you.
So, thank you so much, Dr. Wilfred Matubwa and Mauto Tosa. The idea of dispute settlement gives the impression that, people haven't agreed about something, and so they've come somewhere for the arbitrator or the judge to give a decision. And even from this panel, we can see that we have difference of opinion about the issues. Thankfully, I have not been appointed a judge, and so it's not on me to try and resolve the difference in opinion. But it just shows how some of the issues are intertwined, and more importantly, that most of these issues are evolving, and over time, there might be actual, I'll take his stand and not try and help the drafters or become the drafter, but just hope that at the time they are reviewing, they will take the right decisions. So I would thank the panelists once again. Please let's put our hands together for them. Thank you for your paper.